History as it happens, May 17th, 2022. Slavery in the Constitution.
Americans of every race and color have worked to build a nation of widening opportunities. Now, our generation of Americans has been called on to continue the unending search for justice within our own borders.
When President Lyndon Johnson signed the Civil Rights Act of 1964, he invoked the historic struggle to create a more equal society, one that began with the American Revolution, led to a civil war and the unfulfilled promises of Reconstruction before the triumphs of the 20th century. The nation's first civil rights movement set the process in motion, and it's time to remember their victories as well as setbacks in the political conflicts over slavery and the place of black people in America. Next, as we report history as it happens, a podcast from the Washington Times. I'm Martin DeCaro.
There was no clear, if any, federal power, particularly in the area of protecting individual rights, areas where most of the power to regulate people and decide what their rights were lay at the level of the state. So indeed, when you think about the original Constitution, including the original Bill of Rights or the original constitutional amendments, these were not generally understood to protect people against the states.
Who comes to mind when you think of the civil rights movement? Martin Luther King, obviously. Rosa Parks, John Lewis, the Freedom Riders, who else? What about James Forten, David Blackmore, Edward Abdy? You can be excused if you haven't heard of them. They were dead long before the middle of the 20th century, when Congress finally made good on the promise of Northern victory in the Civil War and the abolition of slavery. Referring to the Civil Rights Act of 1964, the Voting Rights Act of 1965, not the Civil Rights Act of 1866. Yes, there was one. This is the fourth installment of my occasional series, Slavery and the Constitution. And in this episode, we're going to focus on what happened after the Constitution was ratified, right through the Civil War.
Clearly, there's a long tradition in the United States, going back to the Constitution itself, of being really interested in the history of the Constitution, the history of the Constitution's relationship to slavery. And Americans are, kind of obsessed with our Constitution.
Kate Masur is a historian at Northwestern University and the author of Until Justice Be Done, America's First Civil Rights Movement from Revolution to Reconstruction. She was just named a finalist for the Pulitzer Prize, so we're very excited she's here. Our conversation is coming up in a moment. So about the early 19th century, an era of enslavement and racial oppression, as we know, but also an era of gradual abolition in the northern states and a nascent civil rights movement that wielded the Declaration of Independence and the Constitution to try to end racist laws in free states and chip away at slavery in the South and the slave power in Congress. Now, the movement often failed in its aims, but not always. Not in 1849 in Ohio, for instance, when that state's black codes were repealed. And the Civil War and secession opened opportunities for the political embodiment of this movement, the Republican Party, to accomplish the most important goal of all: end slavery forever. So if you've been listening to the earlier installments of this series, like the one with Joseph Ellis that dropped February 1st, if you want to go back and listen to it, you know that we spent a lot of time discussing the debates that produced the Constitution itself, with its clauses that protected or gave power to slavery, such as the 3/5 Clause, the Fugitive Slave Clause. But the result was not a static political climate or any kind of racial consensus. Rather, the American Revolution and ratification of the Constitution unleashed a dynamic process of political conflict at the state and federal levels. Arguments about civil rights and personal liberty developed in the political arena. Each side drew on the Constitution for ammunition. It is a scintillating story of activism and political struggle, of progress and setbacks, a story that opens a window into a bygone era, when Americans thought about and fought over the words in our founding documents. On the way to developing definitions that we might take for granted today. What it means to be a citizen with civil rights recognized everywhere in the country, not just the state or town you happen to live in. Kate Masur, welcome to the podcast.
Thank you so much. It's good to be here.
And allow me to congratulate you on being named a finalist for the Pulitzer Prize for History for your book, Until Justice Be Done. That's exciting.
Yeah, thank you. I was amazed and very gratified by that recognition.
Well, I'm very happy that the book was recommended to me because it fits right in with this occasional series I've been doing, trying to address the question of why we Americans endlessly argue about our origins. We debate what the Constitution said or didn't say about slavery, why that still matters today as we go through this latest reckoning over race and racial injustice. Before we get to some of that heavy stuff, I would like to ask you, what compelled you to write this book now, at this moment in our nation's history, other than the obvious reason that you're a professional historian?
Well, the book came out in March 2021, and I had been working on it concertedly for like 6 or 7 years before that. So, any book that you write, especially if it's about the history of the United States or the history of American politics, it's going to come out into a particular moment, and it may or may not seem relevant to debates that are happening that moment. Although I would argue that, issues of race and inequality are pretty much always relevant to whatever's going on in the moment in the United States. So I wrote this book for a variety of reasons, none of which were directly related to anything that happened in like 2020 or 2021. Among them, one of my questions, and I have a history of writing about Reconstruction, the period after the Civil War. And one of my questions kind of coming out of my first book, which was on Washington, D.C. during the Civil War and Reconstruction, how did there end up being a political party in the United States, the Republican Party, in 1860, 1861, that was prepared not only to take action against slavery, but also to repeal racist laws, basically, like to repeal laws that explicitly discriminated based on race. And I saw that in my first book, seeing how Congress in 1862, when it moved to abolish slavery in the District of Columbia, it also immediately repealed what are called the Black Laws of the District of Columbia. If those laws had stayed in place, all the people now freed by emancipation would be then subjected to these racist laws that applied to free Black people as well as to enslaved people. And how I was sort of wondering, like, how did the Republicans know to do that? How did they decide to do that? They could have only abolished slavery and not repealed the Black laws. And I tried to, think of any works of history that already existed that would really explain that. And there were some books that touched on it, but I didn't feel like there was an adequate explanation for that. And meanwhile, I was also just interested in thinking about the antebellum North, basically the free states between the Revolution and the Civil War as post-slavery societies, and thinking about the continuities between kind of struggling to define a society, a multiracial society in which all people are free, which was not the nation as a whole, but just the free states after the Revolution until the Civil War. And then how did the lessons learned from those struggles get applied to the national context in the Civil War and Reconstruction? So those are some of the questions that were driving me as I was kind of going into this book.
I figured you started researching and writing your book before 2020, so I suppose the premise of my very first question was off a little bit. Why do you think our debates about this subject always seem to go back to the founding and those early years of the Republic, when the conflicts over slavery begin and the conflicts over the place of Black people in American society begin? Those conflicts are often overlooked.
Clearly, there's a long tradition in the United States, going back to the Constitution itself, of being really interested in the history of the Constitution, the history of the Constitution's relationship to slavery. And Americans are, kind of obsessed with our Constitution. It is a very long-lasting Constitution. It's significant that we've had the same Constitution since the founding of this country. And the Constitution, the original Constitution, is also very ambiguous on questions about slavery in particular. And, if it were clearer one direction or another, I suppose it wouldn't be such a fruitful topic to keep going back to. So, but I think that it kind of also depends on who you talk to. People I know who are interested in the histories of slavery and race and legacies of slavery in the United States are not necessarily always looking at the Constitution. I was thinking about this earlier. There's incredible work on the history of housing and housing segregation and housing inequality, redlining, from my own original field of Reconstruction, obviously speaks to these issues. And so I think it also depends on who any person is gravitating toward for these questions, right? Because there's actually just a huge amount of historical scholarship out there.
Our Constitution is revered. I am not in that camp. I enjoy learning about the Constitution, but it's a document written by human beings, and As I learned from reading your book, it was often frustrating how often the Constitution proved to be a pretty flimsy ally, legally speaking, in the fight for civil rights. It was very difficult to use its clauses to support the rights of, say, free black sailors traveling on a boat from a northern state to a southern slave port.
Well, one of the narratives about the Constitution, of course, is that the Constitution was designed to replace the Articles of Confederation and to give more power to the federal government than the original Articles of Confederation had. So to the extent that the Articles were kind of a failed experiment, now you have a Constitution that ostensibly is clarifying some aspects of what the federal government can do. But in my telling, I focus on the areas where there was no clear, if any, federal power, particularly in the area of protecting individual rights, areas where most of the power to regulate people and decide what their rights were lay at the level of the state. So indeed, when you think about the original Constitution, including the original Bill of Rights or the original constitutional amendments, these were not generally understood to protect people against the states. They were only understood to protect people against the federal government interfering with their rights. And so there's a huge amount of power that's devolved onto the states by the original Constitution. And this includes, right, the power to enslave, right? It includes the power to consider people property, right? That's how much power the states have, right? And then among the states' other powers are to decide who can vote, at what age can a person vote, can only men vote or can women vote? Do married women have to give up their property? Do women have any independent existence apart from their husband in other kinds of matters like criminal, legal matters? What are the rights of children? What are the rights of fathers? All of these questions about individuals' rights are determined in the early United States at the state level, and the states have tremendous latitude. And so you mentioned black sailors. In my book, I talk about two different separate areas of struggle over race and civil rights. One is at the state level alone, and then one is at the interstate level. So a lot of Black men in the early republic worked as sailors, sailing out of ports, especially like Boston, New York City, also Philadelphia, these northern ports. Being a sailor was a pretty good job for an African-American man at that time in terms of how much money you would make. In many instances, Black sailors made as much money as white sailors. There wasn't like racial discrimination in the pay scale, although not the same range of jobs was available to Black sailors as white sailors. There was a certain amount of freedom that you would have. You would get to see things and go places. Sailing ships that Black sailors worked on, many of them worked in the intercoastal trade, and they would sail out of places like Boston or New York, put in at ports like Charleston, New Orleans. And this was just kind of the work that they did. They would load up things that were produced in the South, like cotton and rice and things, and bring it either back up to the North or overseas. And Southern states passed laws, starting with South Carolina in 1822, that required free Black sailors from anywhere, from the U.S. North or the many free Black sailors that sailed in the British fleet, some were on French origin ships, required any sailor of African descent to spend their time in port in jail, or in some of the law's cases, it would be spend your time in port quarantined on your ship, to restrict the mobility of these free Black sailors and try to prevent them from, as white Southerners understood it at the time, from spreading, what they sometimes called the contagion of liberty. The idea that these Black sailors would be disruptive, they might tell enslaved people that they could escape, that they could rise up. And once you were incarcerated, or if you otherwise were a sailor and somehow ended up in one of these Southern jails in a Southern port city, you could actually be sold into lifelong slavery if nobody came and picked you up. And so one of the things I write about in my book is how Black sailors would come back north, come home to Boston and what have you, and tell stories about time they had spent in Southern jails, about the other Black Northerners that they met in those jails. And their experiences galvanized people back home to try to do something to get the Southern states to stop these practices. And they considered it an abrogation of the basic liberty and the basic rights of these men. And so, and I'll stop and you can ask me the next question, but this leads to a lot of activism at the state level in places like Massachusetts and New York. The people who want to see these practices stopped, they first approach their own state governments, And then they eventually start approaching Congress and trying to get the federal government to do something about it because it involves interstate issues. And so therefore, they are making the argument that there's a federal role to play here to protect the basic rights of these people.
And Article 4, Section 2 of the Constitution, which we might take for granted today, that I have rights in a certain place, my rights will be respected no matter where I go within the United States. But even then, Article 4, Section 2, there was no consensus over whether the federal government could force states to abide by it or what it actually even meant, literally.
Right. I mean, so Article 4, Section 2, sometimes called the Privileges and Immunities Clause. Article 4 of the Constitution has a bunch of things in it that deal with issues of interstate issues or sort of issues of trying to avoid conflicts among states. And one of the other parts of Article 4, Section 2 at the time was the Fugitive Slave Clause. So these clauses are dealing with what do we do in the event of potential conflicts among states. There was litigation in the early 19th century around, let's say, the rights of white businessmen from one state to do business in another state. So a lot of the primary ways that people were trying to work out what the Privileges and Immunities Clause was supposed to mean in a non-racial or white context. If I am from Delaware, can I go into New Jersey and fish their oysters was a famous case, or can New Jersey say that the oyster beds of New Jersey are only reserved for our citizens, not for any citizens of Delaware, so you can't have them. So that's the kind of question that could arise under the Privileges and Immunities Clause. But the question of whether Black people, free Black people, had rights that were portable, that they could take from one state to another, raised very different issues because states tended to have these explicitly racist laws, and the people who made those laws didn't want to get rid of them and wanted to see them enforced.
Yeah, another remarkable aspect of this time period was citizenship. Was there a federal definition of citizenship? Could each state have its own definition that contradicted the federal one? In this case of the sailors, Massachusetts folks would write letters to the governor. They would, as you said, take it to the state legislatures, try to bring the cases in court. They would say privileges and immunities, Article 4, Section 2. These people are free in our state, therefore, Southern state X, whether it would be Georgia, Mississippi, whatever. You must respect the rights of these free people. But the Southern states would turn that argument on its head and say, no, actually, Article 4, Section 2 respects our view of citizenship.
Yeah, I mean, that's really encapsulated a lot. Basically, what the advocates for Black sailors' rights were saying are Black sailors and other free Black people in our state, let's say Massachusetts, are citizens of our state. And therefore, they should have some number of basic rights no matter where they go in this country. They carry those rights with them. Now, this was a pretty innovative argument, right? Because it actually went against the argument that when you're in a place, the laws of that place are what are operative, not the laws of your home place. Now, there's a legal idea of comity, which is actually when you're in a state, the state or a foreign nation, that nation should extend to you some of the rights that you're accustomed to having back home in order to create comity, means like getting along, being friendly. Southern states, of course, did not want to extend comity to free Black sailors. And so they said, no. The way it works is when there are free Black sailors in our state, we're treating them how we choose to treat them. They actually weren't even treating these free Black sailors the way they treated free African Americans from their state, right? Because there were plenty of free Black people in the South, and they did not force them to spend time in jail, right? Part of this issue was about the idea that outsiders, people who came from a different culture, were accustomed to different rules, were going to stir up trouble. And so the trick was, or the question was, and I think this is very resonant in some issues in this moment right now, could you make an argument at that time that anyone would listen to or put into public policy that yes, there was a baseline of rights that all free people in the United States or all citizens were entitled to, that they would carry wherever they went? Or was that not the case? And whatever rights you had, you might have one set of rights in Massachusetts, but if you went to Connecticut, you would have a different set of rights. And this was the fundamental question. And when these folks in the movement approached Congress and said, hey, what South Carolina is doing and what any number of other states is doing is violating the rights of free Black sailors under the Privileges and Immunities Clause of the Constitution. You have to pass legislation to make them stop, federal legislation. And Congress was not about to do that at that time. And they would either say, as a few Northern congressmen said, we totally agree that this is unconstitutional, what's going on. but Congress does not have the power to pass legislation to enforce this clause of the Constitution. And then plenty of other people said, look, it's not even unconstitutional in the first place. So part of what I'm hoping that I'm describing here is the situation that made constitutional amendments like the 13th, 14th, and 15th Amendments necessary in order to change federalism and kind of make a statement about the baseline rights of people living in the United States that were enforceable by Congress, not just some abstract statement, but also in every of those Reconstruction amendments explicitly giving Congress power to enforce.
So the members, the participants in this first civil rights movement, and I do want to get into who these folks were, they had to take their fights to the state level. They found ways to use politics to establish some baseline civil rights. And one trenchant aspect of your work is this emphasis on a legal regime that was commonplace in the 18th and 19th century America, but may have been forgotten now by most people. That is, poor laws and other measures under the state's so-called police powers allowed states to decide who could obtain a settlement within their borders. States had the authority to remove or even expel people who were poor, called vagabonds or vagrants. My grandfather actually was arrested for vagrancy during the Great Depression, so these laws stuck around for a long time. Mm-hmm. They dated to the English tradition, right, in the 16th century, and the Black Codes were built upon this edifice, right?
Yeah. So thanks for that lead-in. So
so my lead-ins can get long.
Well, no, I'm happy to describe. I'm happy to jump in and describe them. So we were just talking about the part of my book that deals with interstate issues and engaging with the U.S. Constitution. But there's another area of the first civil rights movement that has to do with attacking explicitly racially discriminatory laws at the state level. So in this instance, what we're talking about is not crossing state lines, but rather, okay, you're stuck living in a state like Ohio and or Illinois or Indiana, and to some extent a few other states in the North, which these states had laws that said things like, if you're African American and you move into the state, you have to register with local officials. You have to pay a fee to register. You had to get landholders to put up bonds for your good behavior. If you were Black, you were not permitted to testify in court cases involving white people. Your children would be excluded from public education. Black men were not permitted to vote. So these Midwestern states in particular, which came into the Union after 1800, these free states, had these racially discriminatory laws that they were, again, explicitly racist. They use the terms like no Negro or mulatto shall, blah, blah, blah. So explicitly singling out a group of people by race and saying that they have special conditions for living in a place, they have fewer rights, and so on. Some of the book then is about the movement to get those laws repealed at the state level, because once again, these types of laws were not considered unconstitutional under the United States Constitution. There was not really any argument to be made at the time that there was something wrong with this kind of federally, right? And so really the only thing you could do if you didn't like laws like that in your state was try to get the state to repeal them, the state legislature. Now I'll say a little bit about the poor laws. So one of the things I found that I thought was especially interesting was that there is a tradition in, as you mentioned, in English law, going way back in England, that British colonists brought to North America, which basically said that people who were designated paupers or vagrants, poor people who were also itinerant, so probably poor people who were moving from place to place in search of a place to live or a job, people like that did not have the same kinds of rights or prerogatives even to live in a community as a person who was not poor or who was self-sufficient or self-sustaining. And so these poor laws were designed to distinguish, basically to kind of figure out a way to deal with issues of poverty and welfare and relief in this period. And the basic structure of it was if you became dependent and you couldn't support yourself, whether it was because you were disabled, you were ill, for whatever reason, you first would have to turn to your family. But if you had no family there to support you, if you were a permanent resident of a community, you could get support from either the church, in the case of England, or from local officials. If you were a foreigner, like a stranger to that community, you could be involuntarily deported. You had no right to be there. You would be examined and scrutinized and, again, potentially deported. And so in places like Ohio and other places in the Midwest, when they started to, in the early 19th century, adopt these racist laws that targeted Black people in particular, they built those laws on top of this poor law tradition. So they had poor laws already that said paupers and vagrants can be thrown out. They can be looked at. They can be warned if they don't leave and they're dependent. We can make them leave without their consent, without any due process of law. And when they created the anti-Black laws, they built them on top, literally having the same officials, they were called the overseers of the poor, to enforce the Black laws as well as the poor laws. And so what you see here is a kind of interpenetration of ideas about race and ideas about poverty. And this, I think, is really striking. I think a lot of people are now familiar with that idea that there's a predisposition among some people to associate people of color or African Americans with poverty in general. The idea that like, oh, the issue that I'm concerned about is property values in my community. These kind of questions, if you want to call it like discourses or ideas that associate people of color with poverty and kind of concerns about property, go way, way, way back as far as the early republic or even earlier.
And even in a free state like Ohio, which had a state constitution making slavery illegal, everyone was ostensibly free, but some people were more free than others. There were just these vague categories, at least to my eyes, about rights each person could have, rights a citizen could have. I mean, even Abraham Lincoln, right? He believed that there should be a baseline of freedom. Everyone was entitled to be free, but he still did not endorse full political rights for African Americans or citizenship rights. There was a difference there as well between what you had as a citizen, or civil rights were different than political rights, meaning the right to vote or sit on a jury, right?
I think one thing that people sometimes underestimate is how much these categories were debated in this period, right? And sort of some things that we take for granted, or we assume that we know what it means. When I say civil rights, okay, what are you talking about? What's the package of rights or spaces where you might have rights or claim rights that you are including when you say the term civil rights?
Or what it means to be a U.S. citizen.
Or what it means to be a citizen and what does citizenship kind of get you, right? We may think we know what those terms refer to now. We may or may not actually know that, but we certainly, Americans in the late 18th and 19th century were debating these questions. People were parsing and trying to figure out like, okay, if you're a citizen, for example, and they didn't, first of all, have a definition of national citizenship and who was entitled to be a citizen and what it meant in the original Constitution. That just didn't exist. And a lot of discussions of citizenship happen at the state level. Then they would have to deal with these questions of like, well, if you're a citizen, what does that mean? Do all citizens have the right to vote? Well, but do we think that white women are citizens? I mean, we know for the most part, we don't think women should be able to vote, but we kind of think that white women are citizens. So like, what does that mean for our definition of citizenship, right? Just to give you an example, what is the distinction between being a human being and having certain rights, which some people thought were like, let's say, being a free person and having certain rights versus being a citizen and having certain rights. So at all of these different levels, from like personhood to citizenship, then the question of like, well, what is the contents of citizenship? Is it a state status? Is it a federal status? How do these questions relate to questions of race and status? All of these things were being vigorously debated. And there's not one single answer to what Americans thought at the time. It's more that this is a field of debate.
And no consensus over who had the authority to rule on these things.
True.
Even the courts. I mean, there are a lot of reasons I'm happy I didn't live then and I'm alive today. And this is one reason why. You're living in this kind of a legal jumble. Your rights dependent on things you had no control over.
But you might not have experienced it that way either. I mean, that's part of what's kind of interesting to think about. I mean, especially if you were white, you might not have experienced it that way because people aren't always thinking about their rights, right? Like on a daily basis, what are you doing? You are going to work. You might get paid. You are going to get your food. You may be raising your children. And like, you're not always thinking about what are my rights here, especially if you're able to more or less do the kinds of things that you want to do. Right. And so another thing that's worth thinking about is like, when does a question of rights come up? And then how do you kind of try to claim or defend what you think your rights are?
Yeah, agreed. Yes. There's more to life than politics, I suppose, even then. So one of the strengths of your book is how you show the conflicts and the importance of politics, which, as you know from listening to the conversation I had with Sean Wilentz and James Oakes. They lamented what they believe is the denigration of political history and politics. Your book is terrific in that regard. 1849, Ohio repeals its black laws. There were no black people in the Ohio legislature, but there were many white allies, some of whom were members of anti-slavery, anti-racist third parties. So how did they manage to repeal the black codes? After decades of trying, we should note.
So it's a complicated story, but Ohio is the exemplar of this movement for racial equality succeeding at the state level in something very concrete, politically, in politics, let's just say.
Well, that's how you get things done.
Truly, I mean, this book is about politics in the kind of conventional sense. And one of the questions that I was most interested in this book is, how do people actually make change who's in power, get what they want into public policy? Ohio was very divided politically between the two major political parties, the Whigs and the Democrats. And as you can, imagine, when you have a very close partisan situation, the entry of a third party into that situation can actually sway things one way or another. Like if you have 49 Democrats and 49 Whigs, and you have two independents in a legislature, where they go can be the deciding force, right? And that's similar to what happened in Ohio in 1849. But some previous historians had said or implied that the repeal of the black laws in Ohio was really only about a couple of radical people who got elected from the third party. At this point, it was called the Free Soil Party. They were elected in 1848. And then going into 1849, they really played their cards very, very well in the state legislature and allied with the Democrats, which is in many ways unexpected because the Democrats were generally the more racist of the two political parties, to repeal the black laws and send Salmon Chase to the U.S. Senate. But
there's some dealing there, wheeling and dealing a little bit.
Yeah, they're wheeling and dealing. But it wouldn't have been possible to do it if a lot of other legislators, actually from both political parties, had not come around. So if you look at the preceding years, like starting with probably 1844, maybe 1842, but certainly by 1844, you have people reporting out from the legislature that more and more Whigs are favoring repeal of the black laws. And the people who want repeal, who are in the legislature, are saying, like, we just need a few more years to persuade a few more people, and then the Whig Party is going to favor repeal. Meanwhile, you have the Democrats, a really interesting kind of configuration of Democrats. Some are, allies of Salmon Chase. There's more openness in the Democratic Party in Ohio for various reasons to anti-racist measure like that. And so it ends up being a close call which side, the Democrats or the Whigs, are going to ally with the Free Soil people. And it ends up being the Democrats for reasons that I think have to do with this political skills of Salmon Chase, among other things. But all that is to say that I think it's a combination of the political closeness of the two major parties, the savviness of the third party folks, and changing public opinion among white people about the injustice of these laws that leads them by 1849 to repeal the laws.
Yeah, I was wondering if many of those people had a transformation in their view of race, racial values. Apparently enough did to some degree. Maybe they didn't accept black people as their full equals, but they did see these laws as being really anti-American.
Yeah, I mean, there was more and more talk about the injustice of the laws. And it's very hard to measure changing public opinion, right? What tools do we have to apply to the 19th century for which white people actually changed their minds on this? It's very rare to have a diary or something that says, like, I used to think these laws were fine, but now I don't. And so another thing that's hard to measure, but I want to mention, is also the impact of organized African Americans in a place like Ohio. So it is kind of hard to find the various smoking guns where, some white person says, I talked to this black guy I know the other day, and he persuaded me that, I really need to vote against the black laws. Like, these things are very hard to come by. But what we do see in Ohio in the late 1830s and 1840s is a growing mobilization of Black residents of Ohio who were only about 1% of the population, and forming these incredible organizations, based super locally in Black churches, and then starting to organize statewide meetings to petition the legislature for repeal of the black laws, to petition the legislature to give them back their share of the school taxes. If you're not going to educate our children, then we want our taxes back so that we can educate our children. And Black organizing is more and more prominent in the record as you go forward. And eventually by 1848, there's a Black political convention that literally meets in the state capitol that December, I'm pretty sure it is, as that legislative session is opening. A Black convention is meeting in the state capitol in off hours when the legislators aren't there, with all of the media there. It's a big deal. And so there's a level of visibility, and you can really see that they're getting covered by white newspapers. So you can really see that they're making an impact on Ohio politics, even though, right, African-American men are not permitted to vote.
They embraced politics. They probably didn't want to have to compromise over certain things as fundamental as civil rights, but they probably realized it was necessary. They petitioned, which had a long tradition. They used newspapers, publicity. They cultivated white allies. When people hear the words civil rights movement, maybe they think of the 1960s or the bus boycott of the 1950s. You argue the very first civil rights movement in this country began with the American Revolution. Who were the members of this nascent movement? What parts of the U.S. were they strongest? Was it a tiny minority of the population?
So as I was kind of saying, the most determined and most ideologically committed members of this movement were free African Americans. And the people who rise to the surface in the sources are free African Americans who had a measure of education or access to things like newspapers or writing or going to meetings, because that's how we can see them in history, right? Is because they sort of appear in the record. Free Black people did all kinds of things from, for example, free Black sailors coming back and saying, hey, look, this is what's happening in Southern jails, and you need to know, and we need to publicize this. I found evidence that the Black community in Boston, even well before white people were involved, the Black community in Boston was raising money to get people out of prison, get people out of Southern jail. So there's a kind of Black mobilization on this issue. In places like Ohio, you have a lot of adults who were active in the movement had been born in the slave states. So a lot of people were migrants from places like Kentucky and Virginia. Some had been free and were born free, but in a southern state. Others had been born enslaved and came into Ohio, sometimes in some cases as fugitive slaves. One person I was really interested in was David Jenkins of Ohio, born in Virginia, ended up in Columbus, did contracting work around the state capitol. So I think he got to know state legislators because he worked around the capitol. He was instrumental in forming the Black organization, statewide organizing in the 1840s. And he also was one of the editors of a short-lived but really amazing Black newspaper out of Columbus called the Palladium of Liberty. And one of the things that's interesting that I didn't really explore in the book is that quite a number of these Northern Black activists who really got involved in politics and got to kind of understand lobbying and newspaper writing and political parties ended up moving south during Reconstruction and getting elected to office. So David Jenkins actually served in the Mississippi state legislature in the 1870s because he took his talents to a place where he could get elected, right? With a big Black population, you have a lot of white people who don't want to elect Black people to office. If you go to Mississippi, you have a better chance of actually getting elected. So he, was one of these figures who was involved in politics for a very long time and did all kinds of really interesting things.
Sorry if some of my questions overlap with one another, but this does sound like it was a sophisticated movement. It may have been small, but it was sophisticated in the ways they worked for their cause. William Lloyd Garrison, one of my heroes, although I don't admire him as much as I used to. He makes only a fleeting appearance in your book. Why is that? Was he not effective?
Yeah, and then can we come back to whether the movement was small?
Yeah, sure.
Okay, so William Lloyd Garrison, I think, has been appealing to a lot of, he's either appealing or really unappealing to a lot of modern historians. And, some people thought in the 20th century, some people thought he was crazy and maladjusted, and other people thought he was a complete hero. And Garrison is really, really quotable. He was a white guy who sounds more like, of all the white people in 19th century America, Garrison and a few others sound more like modern day anti-racist than just about anyone else. So
he was strident, morally righteous. He was correct about the evils of slavery, so he's appealing.
And he lived his principles But the thing about Garrison is that he really, although he kind of wavered on this earlier in his career, but like by the 1840s or so, he really did not want to be involved in politics. He wanted his movement to be a moral movement. He wanted to continue to speak against slavery and also against the kind of racist policies in the North that I'm talking about. Just to give an example, which came to mind earlier. So there was a legislator in Massachusetts, George Bradburn, who was from Nantucket. And Bradburn had been an ally of Garrison early on. And then Bradburn was like, I'm going into politics. I'm joining the Liberty Party. I'm running for office. He ended up in the Massachusetts legislature. He was the person who pushed the hardest for the state to take a stand on the issue of Black sailors. And I forget the quote, but there's a quote in my book about what Garrison said about Bradburn. And he was like, poor guy. He used to be a good guy. Too bad he's gone so far astray. And what he was referring to was that Bradburn said, I want to do stuff in the legislature. I don't just want to sit here and talk about how evil slavery is. I want to be able to take action on the issues that I care about. I suppose that like saying things is also taking action. But True. What Bradburn wanted to do was turn to politics. And so because I wanted to focus in a very kind of clear and determined way on political change, somebody like Garrison kind of faded to the background in my study. And then people like George Bradburn or a guy named Leicester King in Ohio like came to the fore because they were the people who were engaging legislatures and trying to change policy.
Garrison found himself outside the mainstream of the abolitionist movement, didn't he? For those reasons?
Well, he kind of took himself outside the mainstream, and like many of the abolitionists moved into politics. Everything is really dynamic, right? So I was going to say the more that there were opportunities to join third parties, and then eventually as the Whig Party broke down and there was an opportunity to create what became the Republican Party, doors are opening for ways of expressing anti-slavery views in politics. Those very avenues were actually created by the people that Garrison didn't really like, who were anti-slavery people, right? So it's not that these opportunities presented themselves and some people walked through those doors. It's that Garrison was not interested in creating those opportunities and other people were. Some people who may be listening to your podcast may know this. There's this trajectory from the first anti-slavery political party, the Liberty Party, and then a kind of bigger effort that's more diverse, that takes in more different political views, the Free Soil movement, which is kind of in the 1848. And then there's a lot of churn in the early 1850s about what's going to happen with political anti-slavery, right? What is going to be the next stage and how far can this movement go? And that ends up, for a variety of different reasons, kind of morphing into what becomes the Republican Party. And so let me just add one thing, because this is like presents an opportunity to say one more thing. So you said earlier, well, this movement may have been small, but it was interesting. But the thing is, like, one of the things we know, and somebody like James Oakes or Sean Mullens will talk about, is that the main thing, and everybody knows this kind of like, the main thing that the Republicans coalesced around in the second half of the 1850s was the idea that slavery will not be extended into new territories, right? And we sort of know this, and we know that people thought that for a variety of different reasons. Some people because they hated slavery, some people because they just wanted the West for white people only. But at least this huge new party, which had earth-shattering consequences really, could coalesce around this issue of no slavery in the federal territories. Well, another thing that I believe they coalesced around was the idea of racial equality and civil rights. So by the time of the late 1850s, this was not a marginal movement. This was a movement whose ideas had made it into the heart of the Republican Party. And it's just that, as with the case of slavery, there wasn't anything the Republicans could do instantaneously under the Constitution to implement that policy nationally. There had to be a war. There had to be a whole lot of other things happen before they were in a position to kind of take that to the national level.
I agree with you on that. My question about the size of the movement was more geared toward its earlier days, 1790s, as you explain in the book. There was activity in Philadelphia. One more point about Garrison, and I think this relates to what's happening in our country today. Activism is not enough. Public shaming isn't always that effective. And having read Henry Mayer's biography of Garrison, I know that Garrison was warned about his tactics. You know, obviously slavery is wrong, it's evil, but you just can't go around shaming slave owners and constantly condemning them in public. You're not going to get anywhere. And Garrison, I think the quote was, I am surrounded by icebergs and I want to melt them. I'm screwing up the quote. It was much more poetic the way he said, but basically said, don't tell me to calm down.
I mean, we people living now, we will have our people in history who we like better than others. But part of the goal is also not to pick sides, but to describe what happened, right? People may jump out at us as, oh, I really like this person. But in the end, it's sort of like, what were people actually doing? And, you know, some of the Ohio abolitionists, let's say some of the Ohio white abolitionists who they hated slavery just as much as Garrison. I have no reason to believe otherwise. And they also knew that they couldn't necessarily, it was highly unlikely that they were going to persuade any Kentucky enslaver to just stop owning slaves.
And moral suasion,
so
it didn't work.
They could rail against slavery, and indeed they did. But look, what could they do at home, right? They could demand repeal of the Black laws of Ohio. And there you can be politically effective, right? It's kind of back to the interstate issue. What can somebody in Ohio tell somebody in Kentucky to do? And they can't tell the Kentucky legislature to do something, although there were like these instances of delegations going between the states, right? But anyway, they could try to persuade some other legislature to do something. But for the most part, they have very little power over what goes on in any other state. But they do have some say over what goes on in their state, right? And so this is kind of what got very interesting to me is people, just like people now might look around and say, well, you know, I don't like what's going on in Missouri right now, but I can't really do anything about that. So I'm going to try to focus on what can I do on the issues that I care about here in Illinois or what have you, right? This is kind of logical way of thinking about American politics, even today.
I found the quote. I really did botch it badly. William Lloyd Garrison. I have a need to be all on fire, for I have mountains of ice about me to melt. Well, he certainly gets credit for keeping the issue of slavery front and center with his, I like him, he's a journalist. You can call him an advocacy journalist. He kept the Liberator going all those years. So we can wrap up by taking it to the federal level. Ultimately, this did have to be the issue of civil rights, voting rights, to have a nation where people's rights were universally respected and accepted. It did take federal power in the end. The Civil War, the 13th Amendment, there was a Civil Rights Act in 1866. But the 14th Amendment, is that the most important piece of this puzzle, establishing equal justice under the law?
I focused on the first federal civil rights statute, which is called the Civil Rights Act of 1866, and the 14th Amendment, which kind of are twins or go together, because they're the sort of obvious outcome or result of the movement that I'm talking about. So this is one of the ways that I was trying to do something that historians hadn't really done before. This goes to engagement with other historians. So, for example, my friend Jim Oakes wrote this really good book, Freedom National.
I read it.
And he said toward the end of that book that Republicans of that era were not thinking about racial equality at all. They were thinking about how to end slavery, and all of their energy was focused on figuring out a way to end slavery. And they saw the question of, questions taken up in the 14th Amendment about equality before the law and things like that, and kind of how do you deal with a free society. We will think about that later. Now, Oakes came back in another book and talked more about the ways that questions about racial equality were actually on the table. But I was partly interested in him saying that they weren't in his original book, because I thought they very much were. And there's a lot of discussion, as you were talking about earlier, about slavery in the Constitution and sort of endless discussion of it, and much, much less about what kind of a situation the original Constitution left us in when it comes to questions of civil rights for everyone and questions of race and racial discrimination. And so what I tried to do was write a book that helps explain not the abolition of slavery, which has been done and done and done again, and not the relationship of slavery to the Constitution, but the relationship of these questions of equality among free people that are part of the Constitution and that necessarily became part of the constitutional debate during Reconstruction.
Slavery is one aspect of this larger issue. Civil War is over, slavery is abolished, but we can see reversion immediately in the South, right? Federal legislators, of course, the South was not part of the federal government at this time, or the process of Reconstruction was underway. Federal legislators say, well, we just can't go right back to the old states' rights. We need to do something about this. 1866, the Civil Rights Act, and then the 14th Amendment, which was a necessity in their eyes.
Yeah, I mean, and the usual narrative of that is that they looked at what the Southern state governments were doing during the summer of 1865 and the fall of 1865, Famously, the southern state governments under what's called presidential reconstruction were adopting black codes. They were trying to institute slavery again in all but name. And so along comes the Congress starting December of 1865 and in that congressional session. And they say, you can't get away with this. We've got to have some federal measures that don't permit the states to do this. What I'm also saying is that the terminology that they use, the concepts that they use, the ideas that they brought to bear when they were faced with that decision were forged, were honed, were developed over decades of discussion in the North over the rights of free African Americans. And so that's where the significance of the first civil rights movement comes in, is that not only were those Republicans facing the immediate crisis of 1865, they were also armed with tools and armed with views about how they thought about these things because of the movement that many of them had actually been part of dating back decades.
Yeah, they had to test their ideas over all those decades through so many setbacks, of course, and a lot of injustice. They were able to test their ideas in the arena of politics. I found your book uplifting, even though it really doesn't have a uplifting ending, so to speak. We know what happens with the end of Reconstruction, and really the 14th and the 15th Amendments are ignored.
Yeah, I struggled with the tone and struggled a lot just overall with what kind of a story I was trying to tell. And you have a lot of, in theory, you have a certain amount of authority over that tone as a writer, right? Are you trying to tell a story of triumph, hooray, we got these measures during Reconstruction, yay? Or are you, saying like, actually these, I had a group of high school students one time ask me at a book talk, oh, well, who even cares about this, honestly, because like it was all overturned by the Supreme Court and by, the end of Reconstruction. So why do you even care? So that certainly crossed my mind when I was working on this book too. And I was really gratified by one review that really made the point discern whether it's an uplifting story, an optimistic story, or a pessimistic story. And I think it's both. One of the ways I feel about the history of writing about social movements and race and racism in the United States is that it can be both an uplifting story, a happy, somewhat gratifying story about the success that some social movements have had, about the ways that people have changed their minds. And it can also be a really depressing story because it seems so hard to make progress or to throw off the chains that slavery has continued to wrap around this country.
I think you struck the right balance, and you close with this sentence, that the policies they ultimately pursued did not resolve all the problems they saw, much less those they could not see, says more about the magnitude of the challenge than the significance of their efforts. Or, as I often say, Sean Wilentz said this as well. I'm a big Sean fan, as you can tell. Nothing gets accomplished until it gets into politics. The word progress is in progressive. Now, that's my editorializing. I'll leave you with the final thought if you have anything to share.
No, thank you so much for having me, and this has been a fun conversation.
Kate Masur, author of Until Justice Be Done, America's First Civil Rights Movement from Revolution to Reconstruction. On the next episode of History as It Happens, we're going to stay on the subject of the 14th Amendment, but in a different context, the history of abortion.
It's a very important precedent.
Is it the settled law of the land?
It is a precedent. If settled means that it can't be re-examined, then that's one thing. If settled means that it is a precedent that is entitled to respect to stare decisis.
Supreme Court Justice Samuel Alito's draft ruling overturning Roe v. Wade leans very heavily into history, as did Justice Blackmun's 1973 opinion. What is the history of abortion in the United States? What did our founders say about it, if anything? That's next as we report History as It Happens, a podcast from the Washington Times.